Welcome to the Application Lab. Today, we are reviewing community property in California. By the end of this explainer, you're going to understand exactly what it is, why it matters, and the key details to keep in mind. We've organized the study guide into 5 clean sections to keep things simple. Section 1, what it is. Section 2, 3 key ownership rules. Section 3, the right of survivorship. Section 4, a real-world example. And Section 5, a recap and an exam tip. Let's dive in. Section 1. What is community property? Here is the short version. Any property you acquire while legally married or in a registered domestic partnership is presumed to be owned equally by both people. Since California is a community property state, our ownership rules differ from common law states. Here, an asset is usually owned equally, even if only one person earned the money, signed the contract, or handled the whole transaction. This covers everything from real estate and wages to vehicles and bank accounts obtained while the relationship is legally active. Now let's compare that against separate property so we can clearly see the difference. Separate property usually belongs to just one person. This category includes assets owned prior to the relationship, along with property received by one person as an individual gift or an inheritance. In many cases, income produced by separate property remains separate property, depending on how you manage it. To lock this in your memory for exam day, use this easy memory aid. Before the relationship equals separate, and during the relationship equals shared. It's the cleanest way to evaluate a property scenario when you are facing a test question. Section 2. 3 key ownership rules. These 3 fundamental rules dictate how ownership works. First, the law applies equally to both spouses and registered domestic partners. Second, equal ownership is presumed regardless of who earned the money or whose name is on the title contract. And third, a written agreement can change that classification. For example, couples can use a prenuptial or postnuptial agreement to agree in writing to keep certain assets separate, or even convert separate property into community property. Under these rules, each co-owner holds an exact 1/2 interest in the community property. Because the interest is equal, one co-owner generally cannot transfer or sell the real estate alone if both owners' consent is required. Both partners must legally sign off on a deed, sale, or refinance. Section 3. Right of survivorship. This brings us to a significant risk. Community property does not automatically include the right of survivorship. This distinction is crucial. Many property owners assume their surviving spouse or partner will automatically inherit their half of the property. Under standard community property rules, that assumption is simply incorrect. Let's walk through the standard process. Step 1. A co-owner passes away. Step 2, without specific survivorship language on the deed, the deceased partner's half goes into the legal probate court process or follows their specific estate planning documents, like a will or trust. It does not transfer instantly to the surviving partner. To bypass that probate process entirely, the property deed requires this specific legal phrase, community property with right of survivorship. This is a unique California ownership form, combining the equal ownership of standard community property with an automatic transfer mechanism. When the deed contains that exact right of survivorship language, the process shifts. Step 1, a co-owner passes away. Step 2, the transfer of the deceased owner's half to the surviving partner is automatic. This method avoids the probate process for that specific property transfer. Section 4, a real-world example. Consider Maya and Alina, who are registered domestic partners. Because Maya inherited a mountain cabin from her grandmother before the partnership, it remains her separate property. Later on, they buy a condo in Sacramento using income earned during their partnership. Even if Alina handles all the paperwork and the mortgage is solely in her name, that condo is classified as community property because it was acquired during the relationship with shared community earnings. Section 5. Recap and exam tip. Let's do a quick recap of the foundational principles. 1. California is a community property state. 2. Separate property means assets acquired before the relationship or received as individual gifts and inheritances. 3. Community property means assets acquired during the relationship. And 4. You must use specific deed language to create the right of survivorship. Here is a critical exam tip for you. A standard community property deed means the deceased person's half goes to their estate, not automatically to the spouse. Test questions frequently check if you know the difference between standard community property and property with survivorship rights. Standard means probate or a will is required to legally transfer that half. Take a moment to consider how your own real estate is titled. Does your current deed protect your property from probate? Real estate professionals need to understand these core concepts, but keep in mind that specific title or tax decisions require legal advice from a qualified attorney. Follow the application lab for real estate concepts made simple.